All right, folks, today's case is an absolute roller coaster. We're looking at Matthew Wadsworth, facing sentencing for aggravated assault with a deadly weapon. On paper, that alone is bad enough, but wait until you hear his criminal history. This man has racked up over 20 felony convictions and nearly 40 misdemeanors. That's right, one of the worst criminal records the judge says she's ever seen. And yet, thanks to a plea deal, his sentence is capped at just 8 years. The defense argues Wadsworth is a changed man, finally ready to stay on his medication, face his demons, and break free from his past. But the judge isn't convinced, and neither is the prosecutor, who points out he's still making excuses, even down to denying he used a bat during the assault. This hearing has it all: emotional pleas, shocking excuses, a frustrated judge, and a final ruling that will leave you questioning whether justice was really served. Let's get into it.
Good morning. Are you Matthew Wadsworth?
Yes, ma'am.
And Mr. Wadsworth was previously in court and entered a plea of guilty to the second-degree felony offense of aggravated assault with a deadly weapon. There was an agreement for a cap of 8 years in prison. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
We have, Your Honor.
Yes, sir.
Are there any additions or corrections?
No, Your Honor.
Not from this one.
All right, Mr. Rojas, you may proceed.
Yeah, Judge, it's the cap of 8, the agreement, I think is a cap of 8, and just based on the criminal history alone and the PSI, it looks like
It looks like you did a very good job of getting that agreement.
that's kind of, not that I did a good job, but I think that may be doing a favor to Mr. Wadsworth. However, Judge, there are some things I'd like to point out. If you look at, and I'm talking about his felony criminal history, the first page of his, I guess, rolling into the second page of his felony criminal history, most of those offenses happened in 2002. So he seems to be getting those in bunches. Those happened in 2002. He got sentenced in 2000. All in one. In January of 2002, they all happened.
Right.
Got revoked in 2003 on all of them. I think he did 60 months on all of them. Got some more in October 2002. Then after that, he goes and basically he's in and out until about 2019 when he picks up some more cases. And from 2019 to this present case, he's
From after the 2002 and to the 2019, there were seven additional felonies.
Yes.
7 additional felonies.
yeah.
Go ahead.
And then from 2019 to now, at least, he's able to stay clean. So he tells me that most of the time when he's committing offenses is when he's off his medications. He's been back on the meds now in jail. It's helping him. He's able to think clearly now. We talked about this, and if the court's even going to consider probation, as pointed out in the PSI, the only way he's going to get probation is with safety to get help with his drug issues. And he understands that. He recognizes that. He's willing to do that. He's hoping that you give him a chance to do that, and even if
The defense paints Matthew as a man finally ready to change. They blame his crimes on untreated mental health and drug addiction, claiming he does well when he stays on medication. Here's the problem. Courts have heard this song before, countless times. I'll do better if I just stay on my meds. But probation officers and judges know that promises often crumble once someone is out of custody. So let me ask you, if you were the judge, would you gamble on him one more time, knowing his history, or is that a risk the community can't afford?
I was sexually abused. My parents were drug addicts. I went to prison. You guys forgot something. I hope it don't hurt me, but I got beat up. I had a robbery in 1992. When I got out from that robbery until 2000, when you started, 2002, yes, ma'am. I stayed out of trouble again because I was on medication. It's been my whole life. It's been the pattern of my life. I'm on my medication. I'm a great guy. I'm a journeyman electrician. I'm a father. I'm a grandfather. I spend time with my kids. If I'm off of them, and the reason I got off of them and this offense happened is I was hearing voices. I thought my roommate was holding my girlfriend hostage. It says I hit him with a bat, but it was my walking cane. It wasn't a bat. And I did hit him, and I felt horrible because I found what was going on in my head. Our house burned down, dogs died, and I just kind of went crazy. But I did stop. I did tell in 2000.
Did you hear that? Wadsworth pours his heart out. Childhood trauma, drug-addicted parents, sexual abuse, a burned-down house, even losing his dogs. And yes, it's tragic. But buried in there is the chilling admission. He attacked someone because he thought his roommate was holding his girlfriend hostage. He insists it wasn't a baseball bat, just his cane. But come on, whether it's a bat or a cane, it's still a weapon when you're swinging it in a paranoid rage. This is where excuses blur with accountability. Do you think he's being sincere here? Or is this just another chapter in a lifetime of blaming circumstances instead of himself?
I hear voices, and I can't tell if it's mine or if it's somebody else, or I can't tell.
So, but Mr. Wadsworth, here's the thing.
Yes, ma'am.
And I appreciate what you're saying, and I feel like you are sincere in what you're saying. The problem is you're 51 now, 52?
51.
51.
Fixing to be 52.
And you know you've had these issues.
Yes, ma'am.
You've been given opportunities, and you know I need to be on my meds. And even if I give you a probation, it's only for so long. At some point, you have to stay on your own meds, and you can't require someone else to force you to do that and take a chance with society and the community of you hurting someone else. Honestly, I'm not sure, but I honestly think that you have the worst criminal history I've seen.
I even said that to Mr. Rojas. I said this.
You have 19 misdemeanor convictions. You have 20 others that were either filed.
And there it is. The judge lays it bare. 21 felony convictions, 19 misdemeanors, plus even more dismissed cases. She calls it the worst criminal history she's ever seen. That matters. Sentencing isn't just about one crime. It's about the pattern. And Matthew's pattern is decades of crime, broken probations, and wasted chances. This moment shows exactly why judges lose patience. At some point, the question becomes, is this a man who can ever safely return to society? Or has he proven, time and time again, that he simply won't change?
Oh, I'm sorry.
And then another later in 2019, maintaining a common nuisance of a controlled substance or something like that in Indiana. So the last thing is 2019, which is, in the big scheme of things at your age, not that long ago.
I know, I understand.
Mr. Smith?
Judge, I would point you to his account of probation where he said the part about the baseball bat is not true. A dresser fell on top of him.
I saw that.
He's still not accepting responsibility.
I hit him with the cane.
Hold on, don't
I'm
speak
sorry.
over. I let you talk, so don't talk over anyone else, please.
I believe probation is absolutely right that jail time and probation has not.
The prosecutor doesn't hold back. He points out that even now, Wadsworth is downplaying his assault, still quibbling about whether it was a bat or a dresser. That's not accountability, that's spin. Probation? Out of the question. Prior jail time? Didn't work. Prior probation? Revoked. At this point, the prosecutor is basically saying, enough excuses. He's had chance after chance, and the community deserves protection. What do you think? Should the court have gone even higher if not for the plea cap? Or is 8 years already generous given his history?
That you entered your plea of guilty. I'm going to find sufficient evidence to find you guilty, and at this time find you guilty of aggravated assault with a deadly weapon. Sentence you to a term of 8 years in the institutional division of the Texas Department of Corrections. There will be an affirmative finding of a deadly weapon. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Rojas. There's help in prison for you with medication. It's going to be up to you when you.
And there's the final ruling. 8 years in prison, with a deadly weapon finding that bars him from ever legally owning a firearm again. The judge admits she almost rejected the plea deal, calling it ridiculous given his record, but ultimately she sticks with the agreement. This case raises big questions. How many chances should one person get? Is addiction and mental illness a reason for mercy, or just another excuse for decades of crime? Now I want to hear from you. Was 8 years enough for a man with one of the worst criminal records this court has ever seen? Or should this deal have been thrown out completely? If you found this breakdown as shocking as I did, smash that like button, drop your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom drama. Because cases like this show just how thin the line is between mercy and punishment.